Hi, Alicia Catherine Daniel, owner of Genesis Law PA, an estate planning and probate law firm here in Florida. If this is your first time visiting my channel, welcome. Please don't forget to like and subscribe so that you will be updated as soon as I upload new videos about estate planning and or probate. In this video, I'm going to talk about inheriting Florida homestead and whether probate is going to be needed in order to transfer title to that homestead. To determine whether probate is going to be needed, you need to first know how the property was owned. Did mom or dad own that property by themselves? Did they have someone else on title? Or was the property in trust? Now, there are different ways that the property can be owned, and that is reflected on the deed. I would recommend that you have a licensed professional take a look at that deed and provide you with an opinion about whether title to the property passed automatically because of the way the deed was written. If the property was owned by a trust, which means it was properly transferred into the trust before your loved one passed away, then title is going to transfer outside of probate, and it's going to transfer in accordance with the terms of the trust agreement. And then finally, if the property was owned solely in the name of that individual, or let's say we have a deed, we have someone else's name on the deed, but because of the way the deed was drafted, title doesn't automatically transfer to the other owner, in that instance, then yes, probate is going to be needed in order to transfer that property and title to that property to the beneficiaries or heirs. Now, once you have determined that probate is in fact needed in order to transfer title to the homestead, the next thing you're going to logically want to know is who is entitled to inherit that property. And this is going to be determined by a number of factors. First and foremost, is there a will? Did the person who passed away have a spouse? And finally, are there any minor children involved? If there is a will, then generally you're going to follow the terms of the will in order to determine who the beneficiaries are. You might have a situation where the will leaves the property to person X, but because that person was survived by either a spouse or a minor child, we actually have to ignore the terms of the will, and we have to transfer the property in accordance with Florida statute. And finally, if title to the property did not transfer by the deed, by the will, or by a trust, then we will transfer the property in accordance with Florida law. And that law is called the rule of intestate succession, or intestacy. If you are in need of probate assistance for the estate of someone who died either as a resident of Florida or owning property here in the state of Florida, click on the link below to schedule your probate consultation. Again, Alicia Catherine Daniel, owner of Genesis Law PA. Thank you.